The number you have reached, 911, has been changed to a non-published number.
Next, let's talk about evidence. And we're going to start by talking about character evidence. And that's Argenbright against Commonwealth. There are two tests to determine whether character evidence can be offered on the defendant's behalf. The first is if the testimony is offered for proper purpose. The second is if proper foundation is laid. The two purposes which character evidence can be offered for is reputation for pertinent character traits, which would make it unlikely that the defendant, if he had these character traits, actually did the crime. And if the defendant has come up to the stand and testified himself, and his own truthfulness has been, or that character trait, a pertinent character trait has been attacked, well then the defense can offer character evidence to counter that attack. The case goes on to say that, in larceny cases, truthfulness is something that you can offer to counter whether or not the person actually did the larceny. And admissible character evidence may not be testimony about specific acts, personal opinion, specific customs, specific courses of action, or a special reputation coming out of a specific circumstance, specific happening. Character witness may only summarize what he has heard in the community. Basically, the character witness can only give hearsay evidence. And a trial court that excludes testimony of witnesses who could not state that they had, multiple conversations with people about the truthfulness of the defendant was within its discretion. This trial court held people really tight. Unless they could say they discussed with several people the truthfulness of the defendant, then he wouldn't allow him to testify. Basically didn't allow anybody to testify. And any judge that holds it that tight is basically going to keep character evidence out. Because how many times do you actually walk up and have that conversation about that pertinent character trait with multiple people? You don't sit around and go, yeah, John's truthful. John, what do you think about John? Is he truthful? Yes, he's truthful. You just don't have those conversations very often. You get general feels, and general feels not going to be enough. And that's personal opinion usually. So under this case, it's going to be hard to get character evidence in. Okay, attack on a witness. Andrews against Commonwealth. This is a case where the witness and who is a co-defendant, and they're both in the jail, and the defendant tries to attack the witness, cursing him out when he tries to attack him. Defense objected to the introduction act, saying, look, there's nothing in there that says it has anything to do with this case. It could have been about, all sorts of things. It could have been that they owed him money, they just didn't like each other, whatever. And the court says, when a defendant attacks and threatens to kill the co-defendant while they're both in jail, yeah, that's probative of consciousness of guilt. And when the defendant takes that act of aggression against another witness, well, the primary question is what the effect of the attack would be, and the person or persons to decide what that is the finder of fact. So basically this goes to a jury. You get to introduce an aggressive act against a witness, and it goes to a jury to decide what exactly that act meant. Hearsay. Again, Andrews against Commonwealth. Using an NCIC to show that an unknown police officer took a report from a relative of the defendant reporting the theft of a weapon of the same type the defendant used is inadmissible hearsay. Basically, the Commonwealth was trying to prove that he had access to this weapon, and it's just stretched it a little bit too far there for the courts. Andrews against Commonwealth again. Defendant is forbidden, since the defendant is forbidden to introduce evidence about conditions in the prisons, the Commonwealth, the prosecution, is forbidden to argue about conditions in the prisons, how wonderful they are, when he's doing his closing argument. Kind of makes sense because otherwise you're going to get that cautionary instruction. If you're lucky, if you're unlucky, the judge will reopen and allow the defendant to put on all that evidence about how terrible it is in prison. Next, we're going to talk about substantive law. Start with violent crimes. Involuntary manslaughter. Involuntary manslaughter caused by an otherwise legal act only occurs when a legal act is done in a method so grossly negligent as to show a reckless disregard for human life. Gross negligence is criminal negligence when acts of wanton or willful character are committed or omitted that show a reckless or indifferent disregard for the rights of others under circumstances reasonably calculated to produce injury, or which make it improbable that injury will be occasioned, and the offender knows or is charged with the knowledge of the probable results of the act. In other words, you do a bad act, but it's legal, and the probable consequences is somebody's going to get hurt, well, then you can be charged with manslaughter. Gross negligence need only indicate a callous disregard for human life without rising to the level of malice. Of course, if it was malice, it'd be murder instead of manslaughter. The grossly negligent act must be the proximate cause of the death. Prosecution does not have to prove that the defendant knew her acts would cause a death, but only that she should have known that her act created a substantial risk of harm. Noakes is a case where a lady was babysitting a bunch of kids, but she had one kid in a crib. The kid wouldn't lay down. She put a dog cage over top of the crib, folded up dog cage over top of the crib. The kid got up there, got his head stuck between the crib and the dog cage, and choked to death. And so Noakes was found guilty of manslaughter. Capital murder. Multiple murders. And this is Andrews against Commonwealth, as we discussed before. You can't convict a defendant. Well, you can convict a defendant under both, multiple murders at one act or multiple murders over a 3-year period, but you can only be punished on one of those. Otherwise, it violates double jeopardy. Capital murder, sentencing, witness testimony. Andrews against Commonwealth again. Although testimony of unadjudicated crimes is allowed to show future dangerousness, and victim impact testimony is allowed to show violence, testimony about victim impact from an unadjudicated act is not allowed. It's just too far out. And it's not the actual victim of the crime that someone's been convicted of. And finally, we get in the other section, Section 29.1-553, selling wild animal parts. This is Goebel against Commonwealth again. And basically, going back, the phrase, except as provided by law in the statute, requires a statutory defense. In other words, the statute says, you can't stuff and sell animals, you can't do anything with that, basically without a taxidermy license, except as allowed by law. And the defendant has to prove that he had a right to do it by law.